set out in TRIPS. Australia, of course, had a comprehensive regime pre-TRIPS, but it has had to fine-tune it in light of TRIPS. TRIPS is both a radical and a conservative document. It is conservative in that it makes no dramatic changes to the well-understood and quite old concepts of intellectual property. It takes all of the recognised rights as given. It defines them in traditional ways. It gives traditional rights and remedies. It does nothing radical insofar as the substantive law is concerned. It's a tight document. It is probably only 10 or 15,000 words long, but it deals with all of the recognised traditional forms of intellectual property and some new ones, such as Plant Breeders' Rights Acts. Plant Breeders' Rights, the creation of new plant varieties through genetic engineering. So it is conservative, but it is also radical in that the intent of TRIPS is to set out a completely uniform code of intellectual property protection through the major trading nations of the world and of course many minor trading nations. And it's even arguable that once a country signs up for WTO and comes under an obligation to enact intellectual property rights that conform to the minimum threshold requirements of TRIPS, that becomes superior law. It can't be routinely amended. It certainly can't be amended in a way that is hostile to TRIPS. Could the nations of the world amend TRIPS? If they perceive problems in the functioning of intellectual property law, can the nations of the world, the WTO nations, do it? Only if there is unanimity among them. That's one of the features of the WTO system, which has stymied its further development. You need complete unanimity to amend the existing agreements, GATT, TRIPS and the like. There are obvious advantages in having a uniform code of intellectual property rights throughout the world. It has the theoretical promise of protecting bona fide IP rights. Of course, this protection is only effective to the extent that the courts in any given WTO country, and most countries now belong to the WTO, are only effective to the extent that court judgments upholding IP rights pursuant to the domestic legislation based on TRIPS are enforceable. For example, are judgments routinely enforceable in the PRC? Natalie Stoyanov says it depends upon the level of court in the region in China. Enforcement rates can be as low as 20%. In other words, a judgment may not be readily enforceable in the particular circumstances in China. The same, no doubt, can be said of other states. TRIPS, as I said, is radical. A world regime, it is conservative in that it takes the existing substance of the law in this area, the internationally agreed upon law. It has produced some, benefits, of course, for enforcement, but it has also created problems because one of the constant themes in this area of the law is you confer a freedom, a monopoly on one party, you necessarily entrench upon the trading freedom of other parties. Where do you set the pendulum in one factual context to another? I think it'd be fair to say that the substance of the law in this area moves at the pace of a tortoise. The Copyright Act today is, basically not that much different to the regime set out in the Berne Convention over 100 years ago. Law moves at the pace of a tortoise, but the rate of change in technology and science and marketing is such that genuine anomalies, genuine contests as to where the pendulum should swing, be positioned between IP holder rights and non-holder rights. Just a couple of very familiar areas. You'll be familiar with them through your general knowledge. Genetics research, also known as, falls under the broader rubric of biotechnology and includes processes known as gene sequencing and genetic engineering. It's proven to be a very fertile field of medical and scientific discovery. It's produced tests for screening people for genetic susceptibility to diseases, medical diagnostic products and pharmaceuticals. But there has been a tendency, particularly in the United States, where probably most of this research work is going on, for researchers to file a patent claiming a new inventive step, some new gene sequence, and thereby to ring fence that area of knowledge and inquiry, ring fence it against competitive research by other researchers. At last count, there are 3 million patents accepted or pending in the US Patents Office in this area. And this can have the effect, of course, well, the positive is there's the prospect of getting royalties, which can make the creators rich, or their licensees rich, or getting royalties that can fund further research. So you do have the incentives operating. But it is seen also to make research, to retard the pace of research by creating basically a legal minefield for competing researchers. I mean, 300 accepted patents and filed patents pending, patents waiting determination by the Patents Office can have a chilling effect. It has been observed on researchers. Another area where there are plenty of arguments is the supply of medicines covered by patents to developing countries that can't afford to pay Western-style prices. Prior to TRIPS, it wasn't such a big problem. States could exclude medicines from patentability, and some 40 states, but most famously India, did exclude medicines from patent protection. So it made it very easy for generic manufacturers to appropriate drugs, by and large created in Western countries and covered by Western country patents. And so contemporary drugs could be supplied cheaply. That has stopped with the introduction of the TRIPS regime, 1994. That process has been stopped. So now, what can the developing country do? They can obviously source generic drugs that are out of patent, but TRIPS has imposed a patent period of 20 years, so you can wait a very long time for more recent drugs. Developing countries have a theoretical loophole in TRIPS. They can license a generic manufacturer to supply the local market, provided they have sought authorisation or made bona fide efforts to obtain authorisation from the right holder on reasonable commercial terms. This exception has not proven to be particularly effective. Another thing they can do, and this does happen, is to rely on the goodwill of what are described as Big Pharma. Big Pharma has shown a disposition to have tiered pricing and to sell patented drugs more cheaply in poorer countries. There's no question that Big Pharma is entitled to royalties. You need royalties to sustain and give an incentive to the research effort. And the high cost of drugs is not the only problem for developing countries. There are also the costs of, storing drugs and transporting them and administering them. But it does remain the fact that drug prices are a problem. The majority of Brazil's health budget, for example, is spent on purchasing patented drugs from big pharmaceutical countries. And so you get plenty of arguments in that area, but not an easy one to solve, because the countries have signed up for TRIPS, and TRIPS pretty clearly does not permit the exclusion of medicines from patents. Just in conclusion, IP-based products have never been more valuable in international and domestic trade in both absolute and relative terms. The TRIPS regime has increased protection subject as always to that critical question of the enforceability of court judgments in favour of IP right holders in a given state. Digitised IP-based products are very difficult to protect. There are unresolved issues in balancing IP holders' rights and those of non-holders in the context both of domestic and international trade. In certain contexts, there is a real argument as to whose freedom in trade should be preferred, that of the IP holder or the non-holder. The pendulum has to be located somewhere, and the question is, where do you position it? The trend of international IP enforcement does, however, favour the IP holder. The increasing globalisation of trade has proceeded and continues to proceed in tandem with the development and application of intrinsically Western legal codes and remedies, exemplified, of course, by the TRIPS regime. And just to repeat an observation I made, once a country has taken TRIPS on board and has enacted law, it is a very difficult thing to change that law, to minimise it, to make provisions that would break down the rights of holders of patents of pharmaceutical medicines, for example, or to reduce the rights of people who've obtained patents in respect of inventive steps in the field of genetic engineering. TRIPS can only be amended by unanimous consensus of all of the couple of hundred odd WTO members. So TRIPS is quite an astonishing development in this area. It's the biggest breakthrough, I think, since the English Copyright Act of 1709. That's why I say that, in a sense, the English Copyright Act has gone global, for better or for worse. There are strengths in TRIPS, but the difficulty of amending it, both at the WTO level and at a state-by-state level, does mean that there are going to be continuing arguments as to where the respective freedoms of the IP rights holder and the rest of the community, where the balance is to be effected. Thank you.